Hello, and welcome to the first of two webinars focusing on JCT booklets, how to complete them correctly, protect yourself and impress your client. My name is Sarah Elliott and I am head of the construction team at Wedlake Bell, and I'm delighted to be joined today by my colleague Brad Fern, a senior associate in the team. In our second webinar, I will be joined by two more of my colleagues, David Kingsford and Tash Alden. These two webinars are aimed principally at contract administrators, employers' agents and quantity surveyors whose roles involve collating and completing JCT contracts for their clients. In the two webinars, we're going to discuss the importance of JCT booklets and look at particular elements which we commonly see incorrectly completed. We'll discuss the implications of those common errors with some examples and give you some practical tips to use going forward. For simplicity, we're going to focus on the design and build contract, but we will also refer to the standard building contract where appropriate. And much of what we discuss is, of course, relevant to all the other forms of JCT contract. We'll use slides to show particular entries in the design and build booklet as we refer to them, but you might find it helpful to have a copy of the contract to hand. In this first webinar, Brad and I are going to discuss the structure of a JCT contract. Why is the JCT booklet so important? What to do if mistakes are made when completing it. Brad's going to talk about some easy wins, some overarching rules to bear in mind when you're completing the booklet. I'll then talk to you a little bit about how courts interpret contracts in the event of a dispute. And then Brad will look at key points to consider when completing the recitals and articles. And he will also touch on third-party agreements and insurance briefly in relation to the fact that those topics need to be considered at the outset. Finally, I will talk about some thoughts for the future in the brave new post-pandemic world. What makes up a JCT contract? In a JCT contract, the contractor is required to carry out and complete the works in accordance with the contract documents. Each JCT contract contains a definition of the contract documents, which, just as it sounds, is a list of the documents that form the contract. The definition varies slightly from contract to contract, but essentially it includes the JCT agreement, which comprises the recitals, articles of agreement and signature pages, the contract particulars, the contract conditions and the technical documents, including the pricing document. In the case of the design and build contract, when I talk about technical documents, I mean the employer's requirements, the contractor's proposals and the contract sum analysis. And if you are using one, the BIM protocol. Brad will speak in more detail shortly about the elements that form the JCT agreement. So let's think about the importance of the JCT booklet. Generally speaking, it's the professional team and the contractor that prepare the technical information for the building contract, and the lawyers who prepare a schedule of amendments to the contract conditions. One of the main reasons that I enjoy working in construction is the number of different people involved in bringing a project to fruition. Each will have their own role to play and expertise to offer, and each will approach the project with a slightly different viewpoint. All must work together to achieve the common goal. This applies not just to the project as a whole, but to each building contract. As we all know, a great deal of time and effort goes into creating these documents. However, unless the JCT booklet, or using JCT speak, the agreement is completed properly, some of this effort can be in vain. The booklet is an essential part of the contract containing important project-specific details, and due to its importance, many of the contract particulars contain a default option that will apply if the parties fail to complete the relevant details. The purpose of the default options is to ensure the contract is still workable, even if some of the entries are incomplete. However, issues can arise if the default option is not right for a particular project, or the parties complete the entry with text that does not reflect the party's intention. It's really important to remember that if a professional advisor makes an error in completing a contract, then depending on the effect on the client, the professional may be liable in negligence or breach of contract. So if we just consider some examples, which unfortunately are not as uncommon as you might expect. Consider failure to incorporate relevant contract documents. We saw this recently in a contract for a prestigious office refurbishment. The way in which the JCT booklet was completed meant that the schedule amendments and many of the technical documents, unfortunately, did not actually form part of the contract. A second common issue is failure to adequately define sections. And David will touch on this in our next webinar in the context of a case involving a baggage handling system at an airport. But we have also seen the issue recently in a contract for a 5-star hotel development, where the parties had spent much time negotiating liquidated damages for each section of the works. However, the description of those sections were not clear enough and in the contract particulars, and if they had not been amended prior to completion of the contract, it would have meant that the liquidated damages would not have been enforceable. Staying with the liquidated damages theme, you can now see a common incorrect entry for liquidated damages in the contract particulars, which would deny the employer of any remedy for delay. Again, we will touch on this in more detail in our second webinar. Lastly, you can see an extract from a fit-out contract where the entry in the contract particulars suggests that there were no employer's requirements. The contract simply will not work without employer's requirements. And in this instance, actually, the employer's requirements and contractor's proposals should just have been stated to be the same. But it could have been a lot worse if that was not the case. These are clearly traps that we all wish to avoid. And although there are often elements in the JCT booklet that cannot be inserted until the contract is almost ready to be signed, there is much that can be dealt with in advance. And it's in completing the JCT booklet with care and attention to detail and collating the various contract documents that the employer's agent, the contract administrator, or the QS plays the crucial role of bringing everything together to make sure that the contract works as the parties intended. Just before I hand over to Brad, I would like to touch on what can be done if the JCT booklet is incorrectly completed. So once completed, a contract cannot be amended without the consent of both parties. And the most appropriate remedy is likely to vary from contract to contract, depending on the nature of the error and the risks that flow from it. However, a key point to remember is that where the contract has been executed as a deed, it can only be varied with a further deed. If your contract hasn't been executed as a deed, an exchange of letters may be sufficient, but in either example, amending the contract is rarely straightforward, as even if you're only seeking to make one amendment, it may well have knock-on consequences in other parts of the contract and/or implications for related agreements with other parties. Brad is now going to talk about the constituent parts of the JCT booklet and deal with some easy wins.
Thanks, Sarah. As Sarah said, the first section I'm going to talk about is what we consider to be easy wins, and that's really information that needs to be completed that on the face of it looks quite simple, but it's amazing how often we find that that's incorrectly completed. So it's worth reiterating what we mean by when we say the agreement, and really in and of itself it's a short section at the start of the design and build contract. And as Sarah said, the references we'll use in this webinar will be focused on the design and build contract, though of course we will refer also to the standard building contract where relevant, although a lot of the concepts obviously cross across. So in terms of what we mean by the agreement, we mean the sort of front end of the design and build contract, incorporating the agreement recitals and articles. And whilst there may not, on the face of it, be as much information to complete in the agreement as in perhaps the contract particulars that David and Tash will talk about, some key criteria is in essence defined in the agreement, such as the names of the parties, description of the works, contract sum, and the name of key roles such as employer's agent, principal contractor, and principal designer. So it is very important to get these key. And one straight up plea on behalf of my fellow lawyers is for the use of entries which are TBA. And by that, we also mean TBC or TBD, to be determined. We see these time and time again, and really these may undermine the existence of the contract itself, and it may lead to certain elements being indeterminable or unenforceable. In the contract particulars that David and Tash will speak more to, if certain entries are specified to be TBA, for example, if it pertains to payments, elements of the statutory scheme may apply, which obviously wants to be avoided. In any event, it just invites dispute and can be easily avoided by completing the entries correctly. I think one of the best ways to view it is that a contract's meant to be an agreement between the two parties, and it should reflect the entire agreement with no key elements left to be determined or to be agreed. If the intent is to agree them at a later date, more often than not, we see that they're either not agreed at a later date or perhaps are agreed but not documented properly, which again then just leads to dispute about what the parties have agreed. I think a good rule of thumb is to ask yourself, if you've put an entry to be agreed, should you be progressing to engrossment at all before sorting it out? I'd like to talk briefly about deleted clauses. We all know the JCT booklet and the conditions contained in there, but more often than not, they may be amended by a schedule of amendments to the contract prepared by the lawyers. Now, I think it's important to note that, whilst I'd suggest it's more common than not to see some degree of amendments to the JCT, there will be certain instances where, due to the size, scope, or complexity of the works, the parties have agreed an unamended JCT may be appropriate. But for the purposes of today's webinar, we're going to assume that there is a schedule of amendments that sort of amends the usual sorts of things we see in a JCT. As regards the recitals and the articles in the agreement itself, I think it's fair to say that these are not heavily amended in the same way that certain contract particulars or conditions are, but they should, the schedule of amendments should be borne in mind when completing the agreement, to make sure that you're not completing unnecessary articles or recitals, which could then lead to confusion or indeed dispute. Sarah mentioned briefly default entries and the importance of considering and not just leaving it or inputting it correctly to avoid a confusion. Within the agreement, in the articles and recitals, there are very few, as opposed to the contract particulars, items to be that have default provisions, but it's worth noting two, which is Article 5 and Article 6, Article 5 being principal designer and Article 6 principal contractor, wherein the default position is that those roles are performed by the contractor. Now, obviously, if the employer has engaged a third party to act as principal designer, or there may be a number of contractors providing works on a project, it may not be appropriate for the contractor to provide those roles. So you should be considering who is providing those roles and then inserting the correct entity as opposed to an individual if it is a company that is providing those services. Another area that on the face of it would seem rather straightforward that I'd just like to talk about is the importance of getting the names and details of the parties correct. Again, it may seem rather obvious, but it's surprising how often we see contracts corrected with incorrect employer or contractor details. As regards the employer, obviously liaise with the lawyers if you have any confusion or queries regarding that. But I think a good rule of thumb is to assess if the employer has a relevant interest in the property, be it legal or beneficial, which we won't go into that. But if an employer has no interest in the property, then they may not be the correct entity to be entering into it, as if a dispute arose, there could be arguments that they've suffered no loss run against them. Now, more often than not, properties may be held by special purpose vehicles, and usually it is those entities that will enter into the construction contracts and appointments, as they are the parties that may suffer a loss if there is a defect in the works or the services. As regards getting the parties' details correct, it's important to check the relevant company's registry website, and these details are on the slide you can see now. It's important to note again that most, not all parties will be registered in England, Wales or Scotland, and you may need to look further afield to Channel Island registries such as Guernsey or Jersey to get the relevant details of the parties. Also, it's very key to check it just prior to preparing the engrossment version contracts to make sure that all the details are up to date. We've seen many occasions where everyone may be clear as to the identity and the relevant details of the parties, but unbeknownst to the lawyers or the technical advisors preparing the contract, they've gone and changed their name or their registered address during the course of preparing the contract and not told anyone. So it's important to check those details prior to preparing the engrossments to make sure that they are all up to date. The last point under the easy wins that I'd like to talk about before handing back to Sarah is as regards execution and the importance of giving good consideration to non-English or Welsh companies and establishing early on how parties prefer to execute. As we all know, on the relevant execution pages in the JCT, there are a number of options for execution, but these may not cover all required methods, particularly where one of the parties may be a trust structure or may be held in a foreign jurisdiction, such as the Channel Islands, where execution by two directors or by a director and company secretary may not be sufficient. And by way of example, as you can see on the slide, is an example from one of the clients I deal with, where the property is held by a Guernsey company and the construction contract's entered into by that company. And appropriate execution for that company is by one authorized signatory by themselves. We obviously need to include an appropriate execution block to affect that. Now, it may be dependent on what software license, if any, you have for the JCT. You could possibly amend the execution provisions to reflect the appropriate block, but sometimes we may have to print it separately and incorporate it into the contract somehow, because it's not possible to amend the JCT booklet to reflect appropriate form. So that's just something to bear in mind. And again, please pick up with the lawyers if you have any concern as regards that. Now, I'll pass back to Sarah now to discuss how courts will interpret construction contracts.
Thank you, Brad. When disputes occur under JCT contracts, the key to unlocking the differences between the parties is often working out what a particular provision means. And the parties may have wildly differing views about a clause, even after lengthy negotiations and completion of that contract. And for that reason, it's helpful when dealing with the JCT contract, and indeed completing the JCT booklet, to keep in mind how the courts will interpret them in the event of a dispute. The courts will use an objective test to decide what a reasonable person, having all the background knowledge that would have been available to the parties at the time of the contract was entered into, would understand from the language of the contract. And I deliberately emphasize the language of the contract because that is the starting point for the court. They are looking at the natural and ordinary meaning of the language used. And it's what the parties have actually written as opposed to what they intended to write that counts. And the courts don't easily accept that people have made linguistic mistakes in formal documents, particularly those that have been negotiated. And this really highlights the need for accuracy in the JCT booklets. The next point to keep in mind is that the contract will be read as a whole rather than looking at a particular clause in isolation. And I mentioned earlier the importance of understanding which documents form the contract, and I will come back to that again in a moment. But looking at a contract as a whole begs the question of, well, what happens when there are inconsistent terms? For example, what happens when a term in the JCT booklet contradicts or doesn't match a term in the technical documents? With the volume of documents involved in a building contract, this can and does happen fairly frequently. Consider, for instance, a list of exclusions produced by the contractor, which is buried in the technical documents, which contradicts information in the JCT booklet or indeed the schedule of amendments. And that contradiction could be regarding important issues such as design liability or responsibility for site conditions. Similarly, issues can arise where the original tender documents and then meeting or clarification notes are included without specifying how the documents are to be read together. Sometimes two versions of a schedule of amendments, or more frequently, two versions of the contract particulars may be included in error, one being the tender version and the other the final version. As Brad mentioned earlier, sometimes there's a disconnect about caps on liability, with the result that the contract particulars contradict the schedule of amendments. So where there is a discrepancy that cannot be resolved, the courts look for what the parties must have intended. And if the contract doesn't say anything about this, the rules of interpretation generally mean that non-standard words, so those are the ones that have been specifically negotiated for the contract, will override the standard terms. And this could have the rather odd effect of the technical documents overriding the conditions and the JCT booklet, which is likely to be undesirable. So for that reason, the JCT forms include an express provision dealing with this. Here you can see clause 1.3 of the design and build contract stating that nothing contained in any other contract document, irrespective of its terms, shall override or modify the agreement or the conditions. That sounds very helpful so far. But then this is often amended further to include reference to the schedule of amendments. This is all great if the JCT booklet has been correctly completed. However, and it's important to remember this, priority of document clauses can still be overridden if a court considers there's a way to reconcile inconsistent terms. And that may not always have the result that the parties intended. So best practice, therefore, is for those involved in preparing the documents to check and resolve inconsistencies as far as possible. Two further points to keep in mind in relation to contract interpretation. In addition to looking at language and reviewing the contract as a whole, the courts will consider the facts and circumstances known or assumed by the parties at the time the contract was executed. But this is just to understand the context of the contract. So pre-contract negotiations and references to earlier drafts or conversations or emails, unfortunately, are not usually relevant to the interpretation of the contract terms. So if you've got something that was agreed prior to the contract, unless it actually makes its way into the contract, it's not going to help in terms of interpreting the meaning of the contract. Equally, anything the parties say or do after the contract is made will be inadmissible in relation to interpretation of the contract. Finally, commercial common sense will be taken into account, but judges will avoid rewriting a contract in an attempt to assist an unwise party or one who has been badly advised, or to penalise a more astute party. Here is an extract from a judgment where this point is made in no uncertain terms. To give you an example, in the office contract that I mentioned earlier, it didn't matter that the parties had clearly meant to include the schedule of amendments in the contract, or that there was clear negotiation back and forth on that schedule of amendments. The contract just didn't include it, and therefore the employer did not achieve the single point responsibility for design and construction that it had hoped for. The contract had been executed as a deed, and the only way to resolve the issue was to ask the parties to enter into a deed of amendment. So going back to the point about the contract being looked at as a whole, the key point to take from that is to check that you've included all the documents that you intended to include in the contract. And where the starting point is to go back to the definition of contract documents in your contract. And the documents listed in that definition are the only ones that will be included as contractual documents. We frequently see documents such as correspondence, prelims, pre-meeting minutes, and tender documents added to the back of a pack of contract documents, but without being labelled as one of the contract documents listed in the definition. And the result is that it's rather unclear what status those documents have in the contract. And of course, there'll be no operative clause requiring the contractor to comply with them. In our next webinar, David will discuss how to make sure that all of your documents are properly incorporated. I'm now going to hand over to Brad again so that he can take you through some more of the detail.
Thanks, Sarah. If the first section I talked about was what we considered easy wins, sort of rather straightforward information that can sometimes go wrong, this section here, now looking in more detail at the recitals and the articles, is perhaps to be titled "The Devil's in the Detail," and to look at how to get it right and discuss examples of what happens if indeed it goes wrong. Looking first at the recitals on the face of it only have one item that needs to be completed, albeit a very key one, and that is, of course, the definition of works in the first recital. It's important to include there a general description of the works and design being undertaken. Now, you may say, obviously, if you've got a very valuable and complex project, I think the JCT gives you all of about 3 or 4 lines in which to describe it as the works. But obviously, as Sarah has said, the specifics of it will be defined in the technical documentation, in the employer's requirements, contractor's proposals, contract sum analysis, and she's just discussed the importance of labeling them correctly. Obviously, if not, then it may lead to the contractor's obligations and pricing for the same being vague and unclear. The standard building contract is the same as regards the definition of works. However, you'll also need to define in there the contract drawings and importantly, the contractor's design portion, where the contractor is undertaking an element of design. And that obviously needs to be completed correctly with a correct description and reference. And it's important there to have in mind and define appropriately the scope of the design responsibility that the contractor is undertaking in the standard building contract when there is a CDP, and to make sure that there's no conflict with the underlying technical documents. So there may be an argument as to what extent the contractor's design responsibility is under that contract. And the other important point to note as regards the recitals is, even though there is just the one element for completion being the works, several of the elements of information set out in the recitals will in turn be completed in the contract particulars. An example of this is the sections, of course, and again we come back to making sure that the schedule of amendments doesn't amend it, and you can see how all these different elements of the JCT are interlinked, and obviously you need to read them all effectively as one document, even though they may be spread out. Looking then at the articles, obviously one of the key ones to complete is the contract sum, which obviously, along with the works, is really one of the key criteria as to how much the employer is paying for these works. One point I would say is very important is to obviously, as you go along, you may have a draft contract prepared, but obviously double check prior to engrossment that you are reflecting the latest contract sum from the latest contract sum analysis. We quite often, obviously, these things may be a movable feast right up to the end, and we quite often get engrossment versions where the wrong contract sum may have been included because it had been superseded by a later contract sum analysis. So it's important to get those points right. I'll just mention briefly the use of provisional sums in the contract and how important it is that the employer is aware of these and the effect that they may have on overall cost and time. Obviously, as we're aware, quite often there may be good reason for inclusion of provisional sums when the work is not adequately defined to allow the contractor to price or to program for that, or indeed when an element of works may or may not actually be required. obviously, the provisional sums may be a best guess based on the information available at the time, and as such may actually differ. The actual cost and time implications may differ based on what may be included in the contract, and as a result, there may be additional time and cost implications if poorly defined provisional sums are instructed. So it's important that the employer is made aware of the possible effects of the same. Another key element that needs to be completed within the articles is the specification of the employer's agent under the design and build, or equally the architect and / contract administrator under the standard building contract. One point I'd say at the outset is quite often we see that people may know the employer's agent on a project to be an individual person, but it may be the actual entity for which they work that is that has been appointed in that role. And it's key to specify the entity, because of course an individual person may not be engaged for the whole of the project for a variety of reasons. And it's also key to consider appropriately and insert the full details of the party doing that role. Now, that may seem obvious, but as you can see from the slide, this is an example where I've obviously made a redaction to protect the innocent, but this clearly indicates a misunderstanding of what is meant under the standard building contract by the role of architect or contract administrator, where in this instance the person has split that definition out to separately define the architect and the contract administrator. Now, obviously, that's not how that term is used in the contract, and it doesn't reflect appropriately the role they're providing. Now, it may be that that is because of some concern on the face of it that role imparts a design responsibility, but it's important to know that it's really a historic term, and what we're looking at here is the certification role under the contract. And if in any doubt, as ever, please discuss it with the lawyers before preparing the engrossment. We've talked about the schedule of amendments and the effect that they can have on the contract, and it's important to read the whole contract, including the contract particulars, as David and Tash will cover in the second webinar, having due regard to their schedule of amendments, because they may amend or indeed delete in their entirety certain elements, and you may be completing aspects that no longer are relevant. It's always good practice that, in particular, as I'm sure David and Tash will say, if you're preparing the draft agreement, including also the contract particulars, to send a scanned draft to the lawyers in advance of preparing the engrossment, because we can normally quite quickly pick up if there's been a misconnect because something has actually been deleted by the schedule of amendments. Now, the schedule of amendments, apart from just being inserted and bound within the contract itself, should also be made clear as to its incorporation. And you'll see normally in a schedule of amendments the insertion of a new, more often than not, Article 10, to sit behind the JCT standard Article 9. But it's also important to replicate that beneath Article 9 itself, either in manuscript or, if you're lucky enough to have the appropriate software license, to insert the text and to get a representative of each party to initial that amendment, just to make absolutely clear that the schedule of amendments as incorporated in the contract amend the terms and conditions to it. Now, I'd just like to talk generally about the effect of other third-party agreements on our building contract. Now, as I'm sure many people are aware, any one project may be affected by a variety of different agreements. Key examples are agreements for lease or license for alterations or funding agreements. Now, these documents are quite often, via the schedule of amendments, defined as third-party agreements, and the contractor will have obligations to conduct the works, not to put the employer in breach of obligations under that etc. So it's important that copies of that are provided to the contractor. They're normally incorporated in the contract documents, and they may or may not be redacted as to commercially sensitive information, but it's important that the contractor have those copies so that they can perform the services, not to put the employer in breach. The other key element of third-party agreements, which is perhaps more on point for completing the JCT booklet and the contract particulars, is that these third-party agreements quite often have certain minimum specifications that may affect the entries in the agreement or contract particulars. Key examples of this are minimum levels of professional indemnity insurance, for example, or minimum rectification period. So you obviously need to be alive to those requirements under the third-party agreements and make sure that the building contract reflects the same. One point I would say, though, is to be careful about the temptation simply to cut and paste some of those obligations from the third-party agreements. You need to consider carefully the effect that they have, and of course, obviously, discuss it with the lawyers if you have any concern. And then the key example I'd say here is in respect of liquidated damages. Now, it's very common for agreements such as agreement for lease to have a rate of liquidated damages if the tenant is prevented from moving in because of late completion of the works. Now, there may be a temptation just to reflect that amount as the liquidated damages under our contract, but obviously our employer may, in addition to those liquidated damages, suffer other costs by way of funding or other associated costs. So we need to wrap all that together in our liquidated damages rate. So that's something to be borne in mind while completing that. The last point I'd like to speak about before passing back to Sarah, who will talk about the brave new world of electronic signatures, is that in relation to insurance. Now, I won't go into too much detail on this because, as we're all aware, that this could be a webinar in and of itself. But just some key points to be mindful of, both at preparation of engrossments, but more importantly at the outset of any works. And one of the key points is establishing the exact requirements very early on as to the insurances required for the works. Obviously, it needs to be appropriate levels of insurance, but also mindful of any minimum requirements in third-party agreements, as I just discussed. Now, this applies obviously to not just to professional indemnity insurance, but to all risk insurance, public liability, employers' liability, etc. Some points for consideration as well are quite often when you have quite sophisticated developer employers who may have a number of properties on which they do works, they quite often have global all risks policies, and they prefer to insure the works under those policies because they have certainty as to the terms of that policy and the level of cover. So whilst it may be tempting just to assume that the contractor may take out all risk insurance, it's important just to be mindful of those, that may be a factor. And also another factor is where the works may be undertaken in perhaps a multi-lettered building. In that instance, the landlord may take out the all risk insurance, or the very least ensuring the existing structures. So again, it's important to be mindful of that, and perhaps the need for any replacement C1 schedule under the JCT to reflect more appropriately the insurance, the agreed insurance requirements, and also to specify and name any joint name parties appropriately. Again, this is one of those elements that seems rather obvious, but is amazing how often it's missed, and that is to ensure that if there is a requirement for specific insurance under the contract, let's make sure that we have appropriate evidence of that prior to execution, because it protects the employer themselves, but they may also be under other obligations under the third-party agreements to provide evidence of that to related parties. And one last point I would say is, particularly this applies more to professional indemnity insurance. As I'm sure everyone's aware, we're increasingly seeing certain limitations or exclusions, more commonly for pollution, contamination, or asbestos, but more recently in relation to fire safety or combustibility. Now, the required level of professional indemnity insurance and basis is stipulated in the contract particulars. So you will need to amend the contract particulars to reflect that, or if it's not easily done in manuscript or not possible through the software license, it may be that you affect this through the schedule of amendments. So obviously you should be discussing the same with the lawyers if you have any concerns. And with that, I'll pass back now to Sarah.
Thanks, Brad. We have seen a huge increase in the amount of building contracts being executed electronically, and in particular via DocuSign. And we expect this to be a common theme in the post-pandemic world. Execution is faster, a full electronic copy of the contract is available to everyone, and the cost of couriering volumes of documentation to the various signatories is avoided. So what's not to like? There are, of course, legal points to consider, and it may not suit every client, in particular offshore clients where electronic execution may not be recognised in the particular jurisdiction. But from the contract administrator, quantity surveyor and employer's agent's point of view, it's really helpful to ascertain early on if electronic execution is to be used, as that will determine how the documents need to be collated. And it's also likely to have an impact on how the contract is executed. Now, Brad spoke previously about considering the parties who will execute the contract. And when we're talking about execution electronically, it actually may be preferable for execution to be dealt with without the need for a witness in person, wherever that's actually possible. So you may need to liaise with the lawyers or consider these options in advance, and so that the execution blocks can be amended appropriately. That brings us to the end of our first webinar in relation to JCT booklets. Thank you to Brad for assisting me, and thank you to our audience for listening. In our next webinar, our colleagues Tash Alden and David Kingsford will be looking at particular elements of the contract particulars which we commonly see incorrectly completed, and providing you with some useful guidance on how to avoid traps for the unwary. I do hope that you will be able to join us. If you have any questions on any of the issues that we have discussed today, please do not hesitate to get in touch. Thank you and goodbye.